Great. Well, thank you for coming, and thank you very much for inviting me. Last time I was speaking here was 5 years ago, and it's great to be back and talking about very similar issues. And it's good to see that regulations in Greenland have evolved relating to public participation, but also interesting to see that some of the debates are the same about getting it right and reaching the people most affected. This presentation is based on a paper that I wrote as part of a project looking at these issues led by the Aran Lule Sami Centre in Norway, funded by the Norwegian Ministry of Foreign Affairs. The core standards that were used for the analysis include the ILO Convention 169, the UN Declaration on the Rights of Indigenous Peoples, the UN Guiding Principles on Business and Human Rights, which partly thanks to James Anaya, who was the special rapporteur at the time, have galvanized interest in Indigenous rights as well as human rights, which, as Rachel pointed out, are often quite different. And I'm also looking in particular, because I'm taking a sort of business perspective, looking at what is critical for business operating in these situations. I'm looking at the IFC performance standards, which are considered to be the benchmark for business. Of course, there are other financial institutions who have similar standards, and the Equator Principles affect a lot more investment in projects, and but they follow the IFC for some of the most critical standards for Indigenous peoples. Also, for the study, we looked at the ICMM, International Council on Mining and Metals, and the OECD guidelines, and a lot of industry guidance, and I won't go into that, but industry associations, ICMM, IPIC for the oil industry, have produced a lot of guidance on this, and also a mention for the Convention on Biological Diversity, who developed guidance on social and cultural impact assessment, which is quite critical too. So the UN Guiding Principles, one of the main things that they did was to determine government and business responsibilities. This was welcomed by business because a lot of focus previously had been on what can businesses do, and sometimes governments were setting businesses up to get a lot of criticism when in fact governments were not carrying out their own responsibilities. So it's made quite clear that government's responsibility to protect human rights, business to respect human rights, and there's quite a lot of detail about due diligence, impact assessment, and so on, and particularly access to remedy. So if something goes wrong, how do people get access to appropriate remedy? Government responsibilities are also established in some of the instruments that I'll be talking about. There are voluntary business standards that have been set up particularly to address issues of weak governance in certain countries. And businesses are also influenced by company policy developed in response to public expectation, awareness of international good practice. So I want to emphasize that here it's, as I think Rachel also said, and Eduardo was saying, that good practice is about going beyond standards in many cases, and then the good practice becomes good practice and is followed elsewhere. And so also worth mentioning is that there are increasing public expectations of government practice now. So public engagement and business risk. Eduardo talked quite a lot about the different business risks, and international standards are used by companies as well as governments to understand and manage risks. And so it's a way to sort of develop a language to discuss community and social risks in an industrial context. And so due diligence in the form of impact assessments or audits carried out on behalf of financial institutions is a way to understand risks and develop ways to monitor and mitigate them. And it's also one way to make sure that commitments made by companies are adhered to. So over time, I work as a company, as a lender auditor, and we have to go twice a year for a period of up to 10 years to make sure that the commitments in the impact assessment are followed by those companies. And so public engagement and consultation become more critical when viewed through the lens of business risk, and increasingly people are starting to see lack of public consultation and effective public engagement as a real business risk. So this is sort of the public engagement cycle, the way it, there may be things missing, but consultation is things that people often think about, but also you need to think about pre-consultation, which Greenland is, of course, thinking about, and the ongoing research and engagement, which is something that also Greenland is doing a lot of, but is maybe not seen as so integral to this picture, but it is in fact. And also very important to think that consultation does need to lead to participation and influence, actual influence over what happens. And then it's an ongoing cycle. As we mentioned, things change within projects, so you may need to come back to doing more research. Ongoing engagement should be happening all the time, as well as the research. But you may need to sort of come back into a consultation process. Consultation may also refer to consent, as we'll be talking about. But this is essentially, consultation is often highlighted and the others are given much less consideration. So if we're talking about stakeholder engagement in the broad sense, the OECD developed guidelines for meaningful stakeholder engagement, which they defined as ongoing engagement with stakeholders that is two-way, conducted in good faith and responsive. So here's a case study in Russia where a company, which I won't name, it signed up to a lot of international sustainability standards and initiatives. It's considered a good Russian company, a responsible Russian company, but in this particular region, they had not engaged adequately with local communities. The communities felt there was a lack of respect, not only because there were frequent oil spills from leaking pipelines in the region, but, and this is one of the challenges of onshore oil, they also had seismic testing without public consultation, which destroyed people's hunting grounds, and generally they did not engage with people, they didn't go and talk to them. This led to a big loss of trust, although legally they were still sort of within their rights. But finally, the resentment built up, and when there was a legal violation, which was failing to consult with the public prior to drilling a new well, this all sort of exploded. The protests went global, a lot of international organizations got involved, and now there are ongoing public protests. But interestingly, the people that I spoke to when we were doing our research, many of them, not all of them, said we are not against oil as, per se. We want the economic development, but we know that companies can work better. We know they can work better elsewhere. So that's what we want. We want companies that are working better. So consultation, what does ILO 169 state? Governments shall establish or maintain procedures through which they shall consult Indigenous peoples with a view to ascertaining whether and to what degree their interests will be prejudiced. This is critical before undertaking or permitting any programs for the exploration or exploitation of such resources, so pertaining to their lands. The exploration side of this often is not followed, and so frequently, certainly seismic testing, but also exploration licenses are given out without consultation with local Indigenous communities. So I'm going to go to Norway, which is a case study specifically which referred to this challenge. This was a gold mine in Norway in a reindeer herding area. The government did not consult with the community prior to issuing exploration rights. The company in question invested a lot of money in exploration and eventually got to the point where they wanted to do an impact assessment, but the local municipality had the right to say no to that, and they said, we don't want the company, we don't want gold mining. But essentially, another interesting aspect of this, the community was predominantly Sami, almost 100% Sami, but the vote was very, very close because about half the population practices reindeer herding, about half the population doesn't, and would like to see mining brought into the community to create local jobs. And this is where the question of who makes the decision, who has the right to make the decision, who are those representative institutions that need to make those decisions. The reindeer herding community did not have the final say. It was a fine balance. The leaders on the council took international standards into account to respect traditional practices, dependency on the land. But in fact, the decision was not related to Indigenous rights in Norway. It was decentralized decision-making regulations. So in regard to consultation as well, many people will know the Berger Inquiry in Canada in 1974, which is still seen as one of the most effective consultation processes that happened relating to energy and extractive industries. This was to investigate potential impacts of a proposed pipeline through the Yukon and the Mackenzie Valley. It took 3 years, 5.3 million Canadian dollars, 40,000 pages of evidence. Clearly, this is something, if it's done properly, it's extensive. It's very highly valued for giving voice to the Aboriginal peoples who would be affected, the ones who would be directly affected by the pipeline. And the result was that Justice Berger recommended no pipeline through the Yukon at all, and for a pipeline to be delayed for 10 years through the Mackenzie Valley. And in 2011, much later than 10 years later, there was another in-depth consultation, also highly regarded, and the pipeline was finally approved. And amongst all of that, local expectations, local considerations, local anxieties were taken into account, and the approval came because the local residents came to approved it and approved the conditions under which it was going to go ahead. So the International Finance Corporation sets out, battling with Rachel on who's got the densest slides here, but the IFC states that effective consultation is about people being allowed to express their views, allowing the client, the company, to consider and respond to them. It's about prior disclosure, dissemination of relevant, transparent, objective, meaningful, and easily accessible information. We were talking earlier about people not being, not having enough information, and I think Anna Sophia's presentation also drew out that the issue of not just giving people information a few weeks beforehand, but building societal awareness so people understand what these industries are about, and so that you can have a proper consultation. So that's all part of the sort of research and engagement side of the cycle. For particularly challenging projects, the IFC has this informed consultation and participation, which is leads to the clients incorporating into their decision-making process the views of the affected communities. So this is actual making sure there is proper influence, not just allowing them to consider. And then at the end, they need to inform those affected about how their concerns are being considered. So these are quite close to some of the best practice in community consent. So if we're talking about impact assessments, meaningful consultation is an integral part of the due diligence process. And the UN Guiding Principles, one of the most quoted aspects is principle number 18, which states that impact assessments to assess potential human rights impacts need to involve meaningful consultation with potentially affected groups. Now, the UN guiding principles have not defined what meaningful consultation is, but a lot of people have tried to, and including the OECD, who developed their guidelines, and various researchers. And I think in general, meaningful consultation needs to have some influence on what happens, and also there are a lot of sort of recommendations around mutually agreeing the process of consultation beforehand, agreeing what is going to be successful consultation, and ensuring, I think here, I mean, this is effective consultation, documenting the outcome so that people are agreed on the fact that it has been a meaningful consultation. On impact assessment, the ILO states that governments shall ensure studies carried out to assess social, spiritual, cultural, and environmental impact. And these should be considered fundamental criteria for the implementation of these activities. And so it's not just an isolated activity that is then put on a shelf, as they often are. It's about determining what happens to those projects. And the Aguegu guidelines of the Convention on Biological Diversity do give quite detailed lists of things that should be incorporated and considered in social and cultural impact assessment. So good practice, I've already said it's not an isolated intervention. Impact assessment leads to In good practice in companies, it's a social management plan. It determines how the project is carried out. It's the basis often of community agreements, impact benefit agreements. It's the basis of an FPIC process. The free, prior, and informed often comes out of the social impact assessment. An impact assessment is about opportunities as well as impacts, or rather opportunities as well as negative impacts. And also, we've been talking with Anne about this, anxiety and expectation and social tension are, as good practice, are now considered to be impacts, and these may happen even before a project begins. And it's well understood in good practice that you need to be considering these. Maybe anxiety comes through a lack of understanding or lack of information. That can easily be addressed by talking with people. So the other thing that we've already talked about, accessible, appropriately timed and located, and culturally appropriate methods of engagement. So this is a picture taken from Sakhalin Island in the Russian Far East, where they went out to the reindeer herding station to talk to them directly, bringing everybody along there and camping, rather than expecting people to come to a cultural centre in the centre of a settlement and being there at an appropriate time on an appropriate day. There's also increasing calls for communities to control the priority setting in impact assessments. The choice of consultants, that's critical, because a lot of the time people don't trust external consultants. Often they're foreigners and they come in, and what do they know? Also participation in data gathering and in the analysis of the data. So a lot more participatory, and that's of benefit to the project, it's of benefit to the communities. So it's, I don't like using the term win-win, but it is a good way of doing things. And then, of course, the results of these assessments need to influence decision-making and outcomes. So here is the question of consent, and obviously we've had these discussions prior to this about consent. I'll carry on later talking about who's Indigenous. So states shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions. So consultation versus consent, often people say that it's an FPIC process. Rachel mentioned that it's often not interpreted as meaning consent, it's not meaning a veto, and that is still sort of hotly contested, but many people would say that if the no is not on the table, then it's not consent, it's consultation. So it's a meaningful consultation process by which Indigenous communities can determine, not only influence, how development decisions are made. It's rooted in Indigenous rights to self-determination and through property, through ownership or traditional use. As we mentioned earlier, it's very important. It's about the relationship of local communities to the land and the effect of a project on that relationship. And it's also about cultural identification related to the land use. Often it's a government responsibility in ILO and UNDRIP, but increasingly industry standards are incorporating a requirement for FPIC in particular circumstances, certainly if there's any resettlement required, and also if there is a significant impact on Indigenous resource use. And as I also mentioned in the discussion, some industry standards extend FPIC to all significantly affected local communities, but the significant factor being their relationship to the land. We also mentioned distinct language and dialect, which is the IFC definition of Indigenous relates to that as well. So the question of representation is particularly critical in Greenland. This quote has always struck me, particularly in the context of the uranium mining debates, where the right of the Greenlandic self-government or the Greenlandic government to make a decision on uranium was held to come out of the UN Declaration on the Rights of Indigenous Peoples, whereas other people felt it needs to have a lot more involvement of the people of Greenland. Self-determination and local control, there are aspects of ILO 169 and UNDRIP which talk about Indigenous people's right to determine and develop their own priorities and strategies for the use of their lands or territories and other resources. So to what extent does that relate to a government or a local authority or communities living on the land and developing those resources and dependent on those resources? So FPIC in practice, the IFC states that they talk about these good faith negotiations between clients and affected communities, and the client needs to document that. So if an auditor is coming in and saying, how did you get this consent? They need to be able to prove that there was a mutually accepted process that was used and approved by the local communities, and also the evidence of agreement between the parties as the outcome of that negotiation. So in Russia, a case study by a company, I can call them Total because they've worked with me on this case study. They were seeking compliance with the Equator Principles and other financial institutions. They had preliminary engagement, which also incorporated ethnocultural research. They developed a multi-stakeholder advisory board, including people from the communities and the government and industry and NGOs. Also, there were authorised community representatives elected by all the communities to be affected in this process. And these people were elected to take part in a dialogue with the company, an FPIC dialogue, with the aim of reaching consent. And so what was the evidence of this agreement? It included a register of comments from all the public hearings, meeting minutes reflecting voting processes that took place in those meetings, video recordings, audio recordings, signed agreements on planned activities. So they collected as much evidence as they could. And then the comments were incorporated into an Indigenous Peoples Development Plan, which was also reviewed by the communities. And then at the end of the FPIC process, FPIC declarations were signed by all of the authorised representatives for those communities. And now engagement is ongoing, and but it's considered to be a successful process of seeking consent. I'd be happy to discuss with anyone who wants to. So the key issues relating to consent, first of all, who is Indigenous? I'm glad we had that discussion previously. Can Indigenous communities veto a project? Does the community agree internally? Because if you think of the Norway case, it wasn't an FPIC process, but the community didn't agree at all internally. And so there is a tool called community protocols, which I'll briefly mention later, by which communities can reach consensus internally on what they want to happen. And there is a need to mutually agree the process in advance, so the company and the community agree the process, including what will consent look like, how will it be reached, how will you know you've got it, who are the representatives, at what level, who has the right to grant the consent on behalf of the community. And as we mentioned earlier, consent needs to be maintained, repeated at critical points in project development. Something may change radically, and you need to be able to sort of reinforce the consent of the community if that happens. And then again, how to ensure that no means no. With the Norwegian case, the company came back again and again to see whether the community might be ready to say yes or not. They had that vote 3 times. So, when does no mean no? And how do you ensure that no means no while leaving things open potentially in the future to change? It's a very interesting discussion. Community protocols, this is one way for communities to develop their own preferences about how they want to be engaged with, and it increasingly being used. This is a case in Canada. The Boreal Leadership Council has developed guidance on good practice in FPIC, and community protocols are increasingly seen as a valuable way for communities to clarify expectations independently of any pressure from an external developer, and to build internal consensus. And this could take a very long time, to establish their priorities, favoured procedures, and so on, or decide together that they want to say no to a project. And also benefit sharing is an important bit of that. So lessons from Greenland, this is my final slide. Ongoing research, information sharing and engagement will build understanding and make consultation on specific issues easier. And I think a lot of good things are being done and need to be sort of part of this engagement cycle. It's important to understand government and business responsibilities, particularly around early consultation. The government role in early consultation before exploration licenses are given out. Certainly in other countries, this has been seen as something that needs to be considered. an early consultation by companies. Maybe it's not obligatory by law, but as a risk mitigation strategy, the Norwegian case again shows that they spent a lot of money in a close to a community that didn't want them all along. So even though it was a close vote. FPIC, I think, and the discussion we had earlier reinforces that it's my opinion that it should be standard for Greenlandic local communities. It doesn't matter whether you call them indigenous or not, and it needs to be maintained over time. Representation within an FPIC or a process or a consultation is important. Who has the legitimacy to grant consent or to make decisions on behalf of the affected communities? An increase in community control over consultation methods, priority setting, choice of consultants, and so on is important, and also is a way to make the processes much more effective. And finally, making consultation meaningful, how to make it all actually mean something rather than just being an exercise, ensuring that consultation enables the affected communities to influence or indeed determine the outcomes. So thank you. This was also here, I think, a prior meeting on the Isukassia project, which I was able to attend 5 years ago, which I wasn't impressed with, I have to say. Anyway, thank you for your attention.
No, I was just thinking that this photo is actually speaking against Birger's thought that it wasn't the males between, what was it, 50 and 69 that was represented in the towns at the meetings.
Some of them might argue that they look a bit younger.
Oh, okay. Just open for questions.
It's the whole language issue. We all know that most of the consultations that go on here in Greenland are mainly in Danish, sometimes in English, and rarely in Greenlandic. And I was just wondering, with the ICCPR Article 27 that says the right to use their own language, are we actually violating the people's right to use their own language by not having presentations in Greenlandic and public consultations where it's going on in Greenlandic? Because there's a lot of translation, but we all know a lot of stuff disappears on the translation.
Could I say this meeting, the main problem I had with it was that they were trying to translate between English, Danish and Greenlandic at the same time. I didn't understand what was going on at all. So it's absolutely, it's really important, and not just a right. You can talk about the right, but it's just being able to communicate with people and have people voice their opinions. They need to be speaking their own language. People need to be able to understand what people are saying in their own language. And translation, certainly 3 ways, doesn't work. But 2 ways, it's very, very difficult, because obviously some of the experts are going to be speaking Danish or English, but you need to be able to allow people to talk in a very spontaneous way in their own languages, and probably in smaller groups than this.
Yeah, the most efficient meetings I've been at are, for example, with Karen, they did have a representative who could speak Greenlandic, and they did wisely decided to back off and let him speak, and it was really effective. So I'll just encourage all the decision makers, maybe actually having it as a requirement that public consultation shall be in Greenlandic.
Add 2 comments on that. You also really need to be thinking about East Greenlandic and the Northern Greenlanders and the languages they speak, which makes it even harder if you're going to be looking into extractives on the east or in the far north. It has to be also accessible in languages, and those people have to be able to speak their language, whether that will almost certainly require some kind of translation going on. I'd just like to add, from the point of our centre, this seminar is in English. I can read Danish, can't speak it, can't understand very much Greenlandic at all, apart from Dekus and Guyana. but we do try to make our findings available by translating short briefing notes, so 1 to 2 pages on what we've been doing, into both Danish and Greenlandic and English. So all 3 are available free of charge on the website, and they're in kind of like ordinary language. So it's not just a matter of language as in, you know, at the high level, it's also a matter of accessible language and not filling slides with acronyms, as I think probably we're both guilty of. Here in a more academic, a more in a different kind of audience, that works. But if you're going into a small community, you can't turn up with a slide on the CERD and the ICCPR and the FPIC and everything else. So it is a matter also of making sure that information is available in an accessible format, which isn't just about being in Greenlandic, it's being in Greenlandic in a kind of ordinary language way. Further questions?
Okay, thank you very much. Really, really interesting. I've never taken part in a hearing here in Greenland, so I don't know much about it. But what I find really interesting is the questions of who are the experts and what are the questions or themes that we should discuss in such hearings. So I would like to know a little bit more about the setting up of a hearing and what kind of knowledge are accepted to go into the hearing and what kind of knowledge are not sort of seen as relevant to include in the hearing. And just to go back to my former question, I don't know, have you, about evaluating former mining projects, have you ever had experience with former mining workers or locals from an area that has been affected by mining, that they were sort of drawn into a new hearing process and sort of talking to the new group, the new potential local community about what kind of questions could be meaningful to ask? Because we're all talking about the future, what will come in the future, and nobody really knows and can make any guarantees. So, I mean, one resource could be to use former mining communities and listen to their experiences. Have you had any sort of experience with that?
I think that's also something for other people to join in on. One thing, the Norwegian mine case that I spoke about, that was a case of a company trying to reopen a mine, and so all the local people had, or their relatives had experience of the mine previously, and all the people who opposed the mine were saying it's because we didn't like what they did, you know, the environmental impacts, the effects on reindeer herding and so on. And some of the people who were pro-mine, they said, well, the community was much more lively in those days, and we had jobs, and, you know, there was more sort of commerce in the village, and we felt a lot more optimistic. So yes, but I haven't had experience of recording those kind of questions, because they didn't get to the point of allowing an impact assessment to go ahead, and I think the people's prior knowledge was very much sort of at the forefront and allowed them to make a very decisive decision either way when they voted. But I think that's a very valuable thing to do, and I don't know if other people have experience of that. And your other question related to, yes, what goes into hearings, and again, my limited experience for this Ilisimatusarfik project hearing was that experts were doing PowerPoint presentations and talking about the sort of environmental impacts. They were quite dismissive about social impacts, and one of the things that struck me was that there had been a series of these meetings, which is probably quite a good thing, so you can develop a kind of community of people talking about things. But what they had done was to sort of gather together a lot of questions, and then they said, well, next time we'll answer those questions. And so the next time they just answered some of the questions and not all of them. And they were all sort of translated 3 ways, and most people felt very, very sort of as though they hadn't had the opportunity for a dialogue. But again, I wonder whether Anna-Sophie or other people might be able to talk about the requirements for public consultations in more sort of with more authority than I can. So I don't want to put you on the spot. But you know, I think having sort of the very scientific, technical, that there's a place for that. But the other types, I mean, we have talked about other types of meetings where people sort of sit and discuss things, and I think a combination of this but doing it better, and you know, other kinds of more intimate meetings with less kind of language challenges and so on is better.
Hi, so just a short question. So in all these projects you have been involved in, is there a discussion on that we actually need the resources, or is it more that we look at it as we don't want it in our backyard, or is there a recognition that we actually want the iPhone and whatever we want, or is it a split thing?
That's a very good point, and I think, because I'm working on consultation in the UK at the moment with a group of sort of consultation experts, and we're trying to sort of develop ideas around that, because sometimes the needs, certainly for iPhones, a lot of people have them, and they're kind of universal. There's also a project in Norway that's doing this, that's hoping to do a project on this, looking at the links between producing regions and consumers, and also recycling materials, and how to sort of bring a greater awareness of the whole aspect of the project. So I think it's really important for people to understand that if they're using minerals, then they need to also consider how those are extracted. But often, you know, it's the people who have got the least technology who end up being the sort of people who, you know, most affected by mining, and I think there's a lot to be said, and I mean, a lot of those people actually want the mine to happen. So it's a very complicated, big picture. But I do think in these kinds of discussions, you often don't really talk about the benefit to society of the minerals that are being extracted. So, although there was some discussion about oil and the use of oil and the extent to which sort of new oil will be, you know, there'll be less and less extraction of new oil, and what are the other things? And if we're talking about that, it's likely to be minerals for renewable energy technologies and iPhones and so on. So yeah, we do need to have that as part of it.
Okay, since no one's waving frantically and we're running rather behind schedule, I'm not going to suggest we've had too much discussion, because I don't believe in that. But let's move on to Karen Booman's presentation, and she's going to be discussing business and human rights between law, politics and the economy. So if I can just ask Karen to come down. We'll just, after Karen's presentation, we'll have a few questions for Karen, hopefully a little time for open discussion, but we will